Good morning, everybody.
Good morning.
I was thinking as we started that it was nice, it was going to be nice to see everybody after the holidays. And it now seems like the holidays were a very long time ago. So it's hard to believe we're kind of rocketing through January, but I guess that's a good thing. But it does give us an opportunity, and I want to spend a couple of minutes as we have been gathering our data, sort of looking at what we've seen. And I think it really illustrates not that we necessarily needed this again, but the importance of our work on this task force, and also some of the things, the new things that we've been doing. Many of you might have seen the recent FBI report that indicated that last year, 2022, Massachusetts had its highest number of bias-motivated incidents in 5 years. So we think of all the work we've been doing, places where we know we've been effective, and yet we still see that. And a piece of our work going forward this year is really continuing that work of engaging and sharing the data, because I do think that if you can't know what's happening in the communities and see what's out there, you really don't know how effective you are being at the work you're doing. And we've just gone through looking at what we had last year. And we had here in Middlesex, 102 incident reports that came to our office. 20% of those resulted in a case, a criminal case going forward. Now, remember, we're encouraging people to report conduct that may be subcriminal. So that number is not at all surprising. We just really want to know about everything that's going out there. And we're getting those reports, some from the police departments, some from people using our form on our website to report, and some complaints that people may seek where people come in for arraignment. And of that, we saw primarily 7 places or groups that were targeted. And in no particular order, those included the Muslim community, Black community, places of worship or churches, the Asian community, LGBTQ community, the Jewish community, and disabled. And the disabled population was somewhat new for us as a countable phenomenon, but unfortunately a growing number. And those numbers will change a little bit, I think, as we continue to finish getting reports from police departments about last year. So that is sort of where we are. As you know, we are continuing and growing our efforts, our outreach efforts. Our social justice roundtables in the high school that we began and thought would be one in a school and finished have really been so popular with the kids that they're now really growing into a series. And Alice and Antonia and so many of our folks have been great about scheduling those and getting out and doing those with the kids. We are also now ready to go. And I remind people, if you have a group, we have our digital citizenship program, which is aimed at middle school kids. So we are working to get that incorporated into the school curriculum. But in the meantime, if you know groups of middle school kids, whether it's scout troops or church groups or community groups, teams, anything, we are happy to come out and do that. You might have just seen in sort of the imitation being the highest form of flattery. Just this week, Governor Murphy in New Jersey signed a bill making New Jersey the first state in the country that will require a course in digital citizenship as part of their core curriculum in their public schools. So clearly this is something that we have to take up and move forward. And we're in the process of working with Governor Murphy's office to try to do something together around the importance of this work. And one of the questions that's come up, and you may have seen a lot of coverage this week, there was an incident, or there've been several incidents up in New Hampshire where some of the white extremist groups have been going out, particularly early in the morning and on ski weekends and leaf peeping weekends, and putting very offensive banners over the highway, dropping them from the bridge. And there was first a real effort on the part of the New Hampshire State Police to identify who was out and doing that. And then this week, the New Hampshire Attorney General charged one of the leaders of the white supremacist groups with putting those banners out there. And I think that has sparked again a conversation about, their claim, obviously, this is free speech versus what do we permit people to be doing. And that individual expression of your thoughts and your opinions, obviously, we believe that to be part of the foundation of a free and democratic society, and believe that everybody, whether we agree with them or not, has the right to be assembling and engaging in public affairs and worshiping the way they want to worship. But the question is, what is the difference? Where is that line between I have a right to say what I think and I am saying things that incite violence? And that's the kind of speech behavior that's prohibited under criminal law. And that's the piece that we've been working on with some of the legislation, clarifying that. And Representative Lewis is here. He's been instrumental in a lot of those efforts, a lot of those conversations. And what's the middle ground? What is it that's in between? It's beyond my right under the First Amendment to express myself. It's not quite, I'm inciting violence, but I certainly am expressing hatred or bigotry based on an individual's being, who they are. And that's bias speech. And even if that is not something we can be prosecuting, that is the kind of sub-criminal behavior we want to know about. That's the kind of thing that we want to be engaging in conversation. We want to be doing community forums about. We want to be incorporating into our education effort. And unfortunately, if you've been sort of following this, and the Globe has taken a particular focus on a number of our suburban communities, this kind of speech is really growing in schools. We are seeing more and more kids, whether they are on athletic teams or clubs, engaging in that kind of speech. The counter to that, which actually was a really good story, if you saw it this week, was an interview with a young Black woman who's a senior at Woburn High School, who has been, her family immigrated here when she was in the 3rd grade. And she does a really articulate discussion of how that school system has changed, how she was always the only child of color, how she didn't see educators of color, to now the principal of the high school is a person of color, and what that has meant for her and what it has meant in terms of community. So it was very interesting because Woburn is one of those communities that's been targeted a lot for some of the behavior of kids. It was interesting to see the other side of that. But we are going to look at this issue today, and this is largely in response to a number of the questions that many of you raised when we asked about topics you were interested in. And I'm really delighted to have with us to lead that conversation, Professor C.G. Dodds from Albany Law School. And Professor Dodds is really an expert on the First Amendment, on this hate speech, how the lines get blurred, and why that departure that we're seeing from civility, from inclusion, has just gotten so much greater. Professor Dodds' research and teaching interests include gender in the law, feminist legal theory, peace studies, critical race theory, immigration, and she's also the co-founder and co-director of the Institute for Racial Justice Research and Advocacy. So, Professor Dodds, I'm really delighted to have you here this morning. I appreciate you taking the
I think Marion froze for a second there, but I think where she was going with that, Professor Dodds, she appreciates you being here and spending your time with us. And we look forward to hearing your comments.
Okay.
Everyone, please use the chat or use your reaction button to raise your hand if you have questions. So I'll turn it over to you.
I thought my computer froze. Okay. So I live on State Street above a bus stop. So if you hear loud noises, that's what's going on. It's a very active bus stop. So I'm very happy to be here with you all this morning. This is actually one of my favorite topics, just because a lot of people don't understand American First Amendment rights and Americans' free speech right. So I'll begin with what is speech? Speech in our system of law, under our rule of law, is any form of expression, meaning it can be verbal, it can be written, it can be audio, it can be graphic. Anything is considered speech, provided that you are expressing, you're conveying some sort of an idea, some sort of a message. So I'm going to begin as though we are in law school all over again, and hopefully I have volunteers and I won't have to cold call anyone. So my first question is, what is hate speech?
I would say it's hurtful language targeted at a person because of who they are.
Okay, hurtful language targeted at a person because of who they are. Anyone else? I need one more person, please. No? Okay. So is burning a cross hate speech?
Yes.
Yes. Yes. Any no's? Okay. Is burning a cross at a Klan rally legal? Who said, raise your hand if you say yes. Any no's?
I think it might vary if it's directed at an individual directly, but I'm not sure if it's in a field and not directed. I would like to have some clarification about
So
that.
just at a Klan rally? Not directed at anyone, just at a Klan rally. They're in the middle of nowhere burning crosses because they have a lot of time on their hands. Okay,
I'd say legal because they're not, no one's there to be intimidated by it other than themselves.
okay. What about burning a cross across the street from a Black person's house?
No, that type of person's being targeted and intimidated based on race, creed, color, religion.
Okay, what if there has been an altercation between that person and the response to the altercation is burning the cross?
Still a target.
Okay,
Uh,
are you saying it is a target or is not a target?
I'd say it is a target.
Okay, it is a target. So even though those are all examples that could be considered hate speech is not per se unconstitutional. And that's where we run into a lot of different challenges because most people automatically categorize a statement as hate speech. And then they say, oh, well, that's unconstitutional. And it's actually couldn't be further from the truth. The US has probably the most liberal First Amendment rights of any country. And so if you were to look at a country specifically like Germany, they have a very strict First Amendment rights. Why? Because of the Holocaust. Because there's a recognition of what speech can actually result in. But in the United States, it's very different in terms of what sort of speech is protected and what sort of speech is not protected. So beginning from the proposition that hate speech is actually constitutionally protected speech. And if I were just to look at different definitions of hate speech, so for instance, there isn't an exact constitutional law definition of hate speech in terms of one that the court has articulated. So these are just some examples of definitions of hate speech that some scholars have come up with that I can provide to you. So one example is expression that abuses or degrades others on account of their racial identity. That's one example of a hate speech definition. Another speech that is particularly harmful because it is a mechanism of subordination, reinforcing a historical vertical relationship based on a person's race, ethnicity, sex, or gender. Another example, a racial insult, whether physical or otherwise, that can cause mental, emotional, or even physical harm to their target. And so the reason why hate speech in particular is always on our minds is because of the results of hate speech. No one can really deny the actual results of hate speech. We've seen it over and over and over again. The question has always been, what is the line? Where does it get blurry? So when it was mentioned what's going on in New Hampshire, the question is going to be, okay, well, was there a crime broken? Was there an individual who was targeted? Did it incite any sort of illegal conduct? Did the words rise to what are considered to be fighting words? Were there specific insults towards an individual? And that's what we're looking at in terms of what constitutes hate speech and whether or not it's illegal hate speech. And so in terms of how you can regulate the First Amendment, there are just very limited means by which you can regulate the First Amendment. Hate speech would be considered to be a content regulation, meaning you're regulating the speech based on the message that is being conveyed. That is subject to the strictest of scrutiny, the strictest of standards. Why? Because we believe in this concept, this philosophical concept of the marketplace of ideas, that as a part of being in a free society, the best way to deal with either unpopular speech, offensive speech, even hateful, degrading speech is to put it out in this marketplace of ideas so that hopefully there will be debate and the truth will come to light. And that is why content-based speech restrictions are held to the highest possible standard. And then you also have time, place, and manner. So you think about those like municipal regulations. What time can you hold a parade? Where can you hold a parade? Do you need a permit to do this sort of thing? So those are typically the regulations that you see on speech. So content, time, place, and manner. Then we have categories of unprotected speech. Remember, hate speech is not unprotected speech. So it is still protected speech. In terms of unprotected speech, we're looking at things like child pornography, of course, obscenity, defamation, and then these categories, which is how you can make hate speech unprotected speech, fighting words, incitement to illegal activity, and true threats. Okay, so those are true threats, incitement to illegal activity, and fighting words are the avenues by which you can get to hate speech. Now, we haven't touched on hate crimes. That's different. And the way that hate crimes work is now you're no longer relying on making a purely constitutional argument with respect to the speech, whether or not the speech is permissible. You're actually attaching it, as you all know. So I'm speaking to the choir here. You're attaching it to an already criminal conduct as an aggravating factor. And that's how we're able to get hate crimes. Because ordinarily there would be a question as to whether or not those statements were constitutionally permissive. But now when you have those statements accompanied with a specific crime or an allegation of a crime, then it can become a hate crime. So the best example of that I can give is I just wrote an article about the Ahmaud Arbery case, and particularly with the federal crime, when the DOJ had more of an opportunity to dig into their backgrounds, they found all sorts of crazy social media posts, calling Black people monkeys, repeatedly using the N-word. There were just tons of posts that you could not, well, I could believe because I'm from the South. And I also live in upstate New York, which strangely enough is, I'd be willing to say, the most racist place I've ever lived in my life. People just aren't honest about it, which makes it even worse. But that's how they were able to arrive at those hate crimes charges, and that's how the hate crimes charges were allowed to stick. There weren't defenses of, well, that's my constitutional right. It was, we're attaching these to the actual crimes that were committed. And so in terms of going the avenues of the illegal activity, the true threats, and the fighting words with illegal activity, you're thinking about it in terms of January 6th. That's the best example that I can give you. Whether or not the person is actually inciting imminent illegal activity is different for a person to get out in front of everyone and say, I think we should overthrow the United States government. Because down with capitalism, down with bureaucracy, the end. That's different if I'm just saying that to a group of people, even if it's at a rally. If I'm saying it to a group of people, this is my cause, the end. If I'm saying it to a group of people and trying to whip the people up to incite them to illegal conduct, to incite them to violence, that's where the speech becomes illegal. And so that's the point that's being litigated right now with all of the different January 6th prosecutions and of course, all of the ongoing DOJ litigation is, was there incitement on behalf of individuals? That's the question. Were individuals inciting violence, or was there maybe one person who as a whole incited different forms of violence and breaking of the law, of course, breaking and entering, storming the Capitol, assaulting police officers. So I think that's the best example of incitement to illegal activity that is tied specifically to speech. Fighting words are words that by their utterance make you want to punch somebody in the face. That's the only thing that I can say. And that's why the hate speech arguments that are often made by the Constitution, I think tend to be very intellectually dishonest, because I think a lot of hate speech actually falls within the fighting words category and can be prescribed on those grounds. Because there are certain things that you hear as a person, it's, at least for me, I feel like I have a moral obligation to punch you in the face. It's just like, I have no choice but to do this. And so that's why the constitutional analysis of it is always interesting, because I think there is a lot of intellectual dishonesty on behalf of the Supreme Court. And then, of course, you have the true threat. The true threat is what I was getting at with respect to the cross burning hypotheticals, because there, burning a cross is unmistakable symbolic speech, especially considering the history of our country. This is not Scotland, where it was a way for people to communicate, where it has that particular history. This is the United States. It has a very clear history. It's for a very specific purpose, which is also how you get into the Confederate flag and why there's such a strange debate over the Confederate flag, of people pretending like it's not symbolic and that it doesn't have a specific purpose. But in order for it to be a true threat, there must be a specific target, right? And an intention to threaten that person, and the person who's targeted must be aware of the threat. So those three elements must be present in order for it to be a true threat. And so what that means is, if the Klan decides to have a rally in the middle of nowhere and they're just burning crosses, yeah, it's hate speech, but it's not illegal conduct. If someone, just as a matter of routine, provided that is permissible by the statutes in the jurisdiction, decides that they just like burning crosses on their yards, hate speech, if it's not directly targeting anyone, if it's not inciting illegal activity, if it's not viewed as fighting words by someone, then it's not illegal activity. It becomes illegal activity once it falls within that category. So for instance, if there's been some sort of an altercation between a person and the person who burns the flag, and they retaliate by not burning the flag, that's a whole different free speech issue, burning the cross, and they retaliate with the cross, okay, now we've entered the territory of speech that can be regulated, speech that can be prohibited, because it's targeting a person. And it can be targeting a person irrespective of their race, gender, or sex. So one of the cases that came up with the Supreme Court was Virginia v. Black, in which there was a Virginia statute that stated that burning a cross was illegal and was per se hate speech, and the actual burning of the cross was evidence of intimidation. Now, the court struck down the part of the statute that said that burning of the cross was evidence of intimidation, saying that that violated the First Amendment because there had to actually be intent, actual evidence of that. However, the state was still allowed to keep up the prohibition that burning a cross with the intent to intimidate someone was illegal. There were no racial categorizations attached to it. It was just a statute, and the court upheld it. So that's what we're talking about in terms of hate crime. And that's how you can attach actual hate speech to a hate crime, even though constitutionally it may present an issue. Now, I want to stop there. Questions?
Professor Dodd, I'm wondering if you could talk a little bit more about the symbolic things that we see, the cross, a swastika or something that is symbolic of hate. And then
Mhm.
we talked about just now that proving that intent. Because I think a lot of times in the improving the crime, right, is that
Mhm.
whole intent piece with the symbolism of what that is. Can you talk a little bit more about that?
So are you talking about in terms of proving that the hate part of the crime?
Well, where you're saying that there's a lot of things that people can see symbolically, there's the hatred in it, and therefore the court might hold that to a higher standard. But then there's also the piece of how that turns into a hate crime where you have to show intent that it is targeted towards someone. But is there some protection in just the symbolism of a picture or of the cross? Or are there no protections there that it's just, we can do that?
You can do it. It's constitutionally protected speech unless it incites illegal activity, fighting words, or it constitutes a true threat. And with respect to the actual hate crime itself, it has to be, for it to be a hate crime, that hate speech has to be tied to an actual crime in order for it to constitute a hate crime. Otherwise, you're just looking at the constitutionality of the speech itself. But the way that hate crimes work, and the case for that is, I can't remember the Supreme Court case, but it's a Wisconsin case. And that allows for actual hate crimes because people have been allowed to circumvent hatred being their motivation for committing a crime by bringing up constitutionality and saying, oh, well, this is my First Amendment right, so it shouldn't be tied to the crime. But the Supreme Court said, well, it can be tied to the crime as an aggravating factor. So it in and of itself isn't necessarily the crime. I think I saw something in the chat.
Yes. Does hate speech become a threat, hate crime, if the private rally mentions specific targets for their activity?
Okay, so the question would be if they mention specific targets. So it wouldn't rise to the level of true threats unless the targets became aware of that. So if they're becoming aware of it, then it could rise to the level of true threats. There would be a question as to whether or not it's inciting illegal activity. So if the purpose of the rally is to say, okay, let's go target these people, then you could make an argument that it is inciting illegal activity. Okay, and I see
I have a question too. I'm just wondering who determines that you are or are not a target? So if somebody actually feels as if they are being targeted, say, for example, we've had people drop hate literature randomly in driveways, but if somebody happens to be a person of color or somebody of the Jewish faith, then how does that determine, who determines who's a target and who isn't?
So that's a proving issue. It's purely that's an evidentiary proof issue. And that is the hard part, because anytime you're proving intent, you have to have some sort of evidence, and intent is just very difficult to prove. We see it all the time in discrimination law and when we're looking at equal protection, where the court has decided that you have to prove intent. It's almost as though you have to have something concrete. Now, sometimes the speech itself can rise to such an egregious level to where it's just unmistakable, that on its face, you can tell what the intent is, but normally that's not the case. There has to be some sort of proof that you're being targeted by a specific person. I see permits, intent.
That might have been earlier in response.
Oh, okay. All right. Any other questions so far?
So, so are we saying, I'll give you an example. So as an African-American, I live in my house and 12 midnight, I wake up and across the street, there is a cross that's being burned there. Now, I'm not aware ahead of time that that was coming. So it wakes me up and that's what I got going. So I understand that, okay, that is not on my property. It's on, maybe public property, what have you. Is this a case where I have to prove, or does the symbol itself, is it large enough to push it into another category, as opposed to this idea of proving intent?
So the issue that you would run into is if you're saying that it's threatening to you,
Yes.
you would still need to prove intent. I know it sounds crazy.
Mm-hmm.
I know it sounds crazy, which is why I said I think the court is intellectually dishonest when it comes to these things. Because the court positions it as it is a person's right to convey that they hate Black people.
Yes.
That is their right. That is their First Amendment right.
Mm-hmm.
And so if you're saying that they're targeting you, you do have a proofing issue. Now, if it becomes over and over and over again, okay, now we're getting closer to it, because then a reasonable person could conclude that, yes, they are in fact targeting you. But if you wake up one night and you see the cross and you don't know anything else surrounding it, then there is an intent issue there. Now, of course, there's also the issue of whether or not there are hate crimes. And because I'm talking about in the broadest, purest constitutional sense, right? Now, if there is any hate crime legislation in your jurisdiction, now there's a different question, because there's a different question as to, say, for instance, the legislation says with intent to intimidate, then it's okay, what does that intent look like? Now, the Supreme Court has said that just burning the flag alone is not sufficient evidence of intimidation. Again, why I say that it's dishonest, because you don't burn a flag unless a cross, unless you are intending to intimidate someone. But you still have those proofing problems, because again, the court says you have a right to say, I hate Black people. You have a right to say, I think all Black people should die. You have a right to say those things.
Mm-hmm. Thanks.
And of course, if there's an ordinance saying you can't burn a cross on your yard, which also probably exists.
Right.
There's more than one way to skin a cat.
Exactly. So that my gated communities have those kinds of provisions in there.
Right.
Right. So that may be advantageous, but that
may-
also means I've got to go and live in more of an isolation,
More of an
which
isolation.
doesn't help us in the longest run. Yeah.
Right. Okay. So what I want to move on to, because I think that this is a particularly salient issue, is schools. Right. We see a lot that's going on in schools. When I was in school, things happened, but to me, there's just been an increase in it. And I don't know whether or not we just know about it more because of the internet and the information is more readily available, or whether or not there's something going on in society to where there is actually an increase in it. So with the schools, and I'm going to talk about student speech right now. And by schools, I mean high school, elementary, and middle school. I'm not talking about college right now. So if we were to think about it in the context of what's been going on at the high schools right now, students have First Amendment rights. The seminal case with that is Tinker v. Des Moines. Students have constitutional rights. The court has held that students don't shed their constitutional rights at the schoolhouse gates. However, given the special environment of a school and the role that schools play in societies, schools may regulate a student's speech. So the schools may regulate student speech under certain circumstances. So for instance, there are categories of speech such as lewd and vulgar speech, obscene speech. Students can regulate that speech advocating illegal drug use, something against the school's policy, speech and that bears the imprimatur of the school. So if a student represents the speech as being the speech of a school, then the school can regulate the speech. The overall standard that is used is what's called the substantial disruption test. So the court looks to see whether or not a student's speech has actually caused a substantial and material disruption of the school environment or school discipline, or impinges on the rights of other students. Okay, that's the first part, whether or not it's actually caused a substantial disruption. The second part is the school doesn't have to wait until the disruption occurs in order to regulate the speech. If the school can reasonably foresee that the speech will cause a substantial material disruption or impinge the rights of other students, then the school can step in and regulate the speech. And that's the idea, that the school shouldn't have to wait until some situation completely blows up in order to say, okay, now you're not allowed to say that. Students are allowed to have expressive symbolic speech. So for example, in the Tinker case, this was a long time ago, students wore Black armbands to protest the Vietnam War. That is considered symbolic and expressive speech. The court looks to see whether or not it's that sort of pure speech. And that's where hate speech is treated differently in a school environment, because there you have students, and it becomes a question of, does it impinge on the rights of other students? Does it cause a substantial material disruption, or is it reasonably foreseeable that it will cause a substantial material disruption? So now we're just talking about what's happening on campus. I hate to say it, but that's an easier thing to deal with. Now we have to go to what happens off campus, right? And there are a few realms of off-campus speech. One that's particularly salient now is off-campus internet speech. That is difficult to regulate because, and if you think about it, it makes sense. The internet is ubiquitous. It's all around us. Everyone has access to it. Anyone can convey a message. And so if you're regulating all student speech, if the school has the power to regulate all student speech, it means students have no First Amendment rights. And that's why there are special circumstances in which schools can regulate a student's off-campus internet speech. So for instance, the speech, it can be regulated if it contains threats towards people at the school, threats towards the administration, if it actually threatens the school, if the speech is reasonably foreseeable. So going back to the idea of the Tinker standard, to cause a substantial material disruption, if it actually reaches the school, if it's the sort of speech that nobody really finds out about, then the school doesn't have an interest in regulating the speech. If it is a situation in which the school stands in what's called loco parentis, so in which the school is acting as the student's parents, or the school is acting as the student's guardian, that's an instance in which the school can regulate the speech. So that's the category of just general off-campus speech. Now we have the category of speech that occurs at games, which is what comes up a lot, speech that comes up at school activities. And that creates another issue because it's a question of who is engaged in the speech and what type of speech it is, and is it an environment in which the school can reasonably be seen to have control over the students. And that's where things get tricky with, like I saw the examples of, I think it was basketball or volleyball games. There's been basketball games, there's been hockey games, there have been all of those different situations. And so what happens in those circumstances is normally you see students engaged in some sort of hate speech. The school says it's going to take action, and it states that this is a disciplinary matter. And technically it is a disciplinary matter, and technically it's up to the school to decide how to discipline for that speech. Schools are very careful about trying not to commit First Amendment violations. And so that's why you see them make these very broad sweeping statements. And of course, also because they have an interest in protecting even the students who have engaged in this speech. They have an interest in protecting those students as well. But they do have disciplinary authority because of the nature of the school, because schools are supposed to teach students to be good disciplines, to be good citizens. They're supposed to be incubators of knowledge. They're supposed to teach students how to engage in the marketplace of ideas. They do have that disciplinary authority, and they're usually given a very broad leeway. So one of the examples that I saw that was sent to me was a school that required the students to do, I think it was something like bias or diversity training. Oftentimes, and this is purely my opinion, schools don't go far enough because I don't think schools fully take into account the consequences of hate speech and what hate speech, how it can impact not just the mental and emotional state of students, but how it can actually physically impact other students. Sometimes schools, because they're so scared of running afoul of the First Amendment, tend to treat these issues lightly. So they do have leeway, but students do have their First Amendment rights. And that's how you run into the issues with things like chanting on high school campuses or at games. And also you have the off-campus speech dimension where students are using Snapchat or Twitter or Instagram to convey certain messages. It's all a very gray area. But schools do have more latitude to discipline students for hate speech because of the school environment and the mission of the school. And if something happens, it can be tied to hate crimes. Okay. I know I went through that very quickly because I know it's early, but thoughts, ideas, comments?
Professor, what would you suggest for the schools that don't go far enough and don't always understand the impact of how behavior can affect other students, like, you know, maybe the victims, but even how it reverberates among the student body? Like, do you have any suggestions on how to deal with that? And are there any, you know, any anecdotal or, you know, studies that talk about that? I know that's probably a long shot, but I'm just trying to figure out how to illustrate that to them.
So I would say, and I can't think of any studies off the top of my head, but I do think that the best way to illustrate it would be to take a Brown v. Board of Education approach, which would be to use the actual studies to show something like that, because empirical evidence always goes further than anecdotal evidence. Anecdotal evidence is very easy to ignore. But when you can actually prove it, then you have something different. Now, if you can prove it in the context of having students themselves who are willing to speak out as far as how it impacts them, then yes, that's also one way to go about it. And you can always drill down on, they have a right to protect students. They have a right to protect students. And even under that Tinker standard, that impinging upon the rights of other students, that's where the school can regulate speech. That's where the school has latitude to regulate the speech. Oftentimes schools, like I said, they don't go far enough, and it requires pretty drastic measures on behalf of the parents to make them go far enough. And so I think a lot of times it's just a matter of how far are you willing to go with it?
Thank you.
Professor Dart, you're going to talk about how it changes. Does it change, or how does it change when it's on a college campus?
So college campus is a lot trickier because number one, you're dealing with adults, right? And so adults have adult First Amendment constitutional rights. They do. Normally, the way it presents itself is whether or not the speech can be considered school-sponsored speech. So for instance, it comes up a lot with clubs. So if there's a club advocating for a particular position, then it's okay, is it school-sponsored? Does it impinge upon the rights of other students? Does it fall within a category of hate speech? And can we look at it as any sort of incitement? Can we look at it as any sort of fighting words? Does the speech actually constitute a true threat, or is it merely just offensive and unpopular opinion? An offensive and unpopular opinion warrants constitutional protection. It oftentimes comes up in terms of, one of the newer cases is with LGBTQ organizations as expressive speech. What does that mean to have it on the campus? Is it advocating for a certain position of the actual school? The fact that the club is even allowed to exist. So normally it comes up when there's funding and when the question is whether or not it's representative of the school or if there's the imprimatur of the school. I know that when I was in undergrad, I went to UNC Chapel Hill and I was a journalism major. This is the craziest story. I went to school the year after 9/11. So I went to college in the fall of 2002. And we were required to read as a part of our orientation, understanding the Quran, because the school didn't want a bunch of bigots running around, irrespective of our board of trustees. The actual faculty didn't want a bunch of bigots running around. Well, we still had some bigots. And there was a question about free speech and the student newspaper, the Daily Tar Heel. And so the Daily Tar Heel decided to print a political cartoon depicting the Prophet Muhammad, because Daily Tar Heel, free speech rights, and we have a right to do this. And we were having a discussion about it in school as to whether or not it should be done. And I remember saying, and I didn't know anything about the law at this time, I said, you know, something like that might incite violence. I'm not saying that it shouldn't be protected speech, but I could see that inciting violence, especially with the knowledge that there are people of that faith who don't believe that Muhammad should be depicted in imagery like that. And I think within the next week, there was an actual terrorist attack on the campus, where an individual came to the campus and drove through what was considered to be the pit area, where all of the students were located. And there were some students who were seriously injured by that activity. And so that's another way that it comes up on college campuses. It can be something like a student newspaper. And there was a really big debate around it. And of course, the outcome of the debate was that it was protected speech under the circumstances, but that's another way in which it comes up on college campuses. So it's a lot more difficult to discipline college students than it is to discipline high school students, because you are dealing with adults. And so it's really looking at, is this speech on campus? Does it look like it's sponsored by the university? Does it receive university funds in any sort of way? Those are the sorts of considerations you're thinking about. How does it impact the student body as a whole? Can it be considered as targeting individuals? And college campuses have recently become recruiting grounds for neo-Nazis. People are actually targeting college campuses heavily. And there's a variety of different reasons. Some of it pertains to the quote unquote culture wars. So the idea that college campuses are too liberal and students who are conservative don't feel comfortable voicing their views. And so they are targeted by organizations such as neo-Nazis for radicalization. And it actually does happen a lot on college campuses. Randomly, flyers will just pop up with these crazy messages in the middle of the night, because people recognize that college campuses are in fact a good place to recruit. As crazy as it sounds, college campuses are a good place to recruit. And they're getting a lot of people from college campuses.
Professor, one of the questions that's come up, unfortunately, in some of our communities is around municipal employees, specifically police and firefighters.
Yeah.
And what kind of speech is permitted, obviously, both whether they're at work or whether it's on their private social media, that sort of thing. And what is your understanding of where the state of the law is about the regulation that can happen there?
Okay, so what you're looking at is you're looking at the Pickering-Connick test, because then you're balancing the interests of the employer with the interests of the employer with maintaining discipline and order in the work environment with the First Amendment interests of the employee. And there the court looks to see whether or not the employee is speaking on what's considered to be a matter of public concern. So something that independently of their employment, they will be entitled to speak about just as a citizen in the United States, and also whether or not it's within the scope of their employment. So for instance, with police officers, you can run into it I see it in very often in a couple of places. So you see it in paperwork. You see it with police, where police officers are making certain statements and there's retaliation for making those certain statements. And you see it on social media, which I think social media is the gift and the curse, because for some reason, bigots cannot resist saying crazy things on social media. And so the question is always, anytime someone is disciplined for that speech, it's, well, these are my First Amendment rights. Employers have a lot of control over the First Amendment rights of their employees when they're in a position such as being a police officer, because the question becomes, what's the interest in maintaining the confidence of the public? When you're making certain speech like that, what bearing does it have on your ability to do your job? And has it impacted your ability to do your job? And is there any demonstrable evidence that it has impacted your ability to do your job? And that's why those cases are also tricky. Because yeah, the court technically looks to see whether or not the speech is made within the scope of your employment. You can actually expand the scope of someone's employment based on what the speech is about. And that's why you oftentimes see people disciplined for it. With respect to police officers, normally the discipline does not stick. Normally the First Amendment rights prevail for a lot of different reasons, mainly because of the power of police unions. They play an integral role in that, but they don't stick. They stick in ways that don't stick for other people, for other employees. Because we often see teachers being fired for certain speech, because it calls into question their ability to do their job, public confidence, all of those sorts of things. Because when you have a state job, you are seen in a lot of contexts as representative of the state. And times that I've also seen it as teachers saying things about their students, saying degrading things about their students on social media. Terrible idea, but people do it. And that's why I say social media is the gift and the curse. I don't participate in it. Because I do think it's very easy to say something that goes terribly wrong, even if you don't intend to do it. But there are some people who feel empowered by it because they don't understand the First Amendment. They don't think that First Amendment speech can be regulated, and it can be.
Other questions, thoughts? There's a lot of information there.
I wanted to follow up on your comment, Marianne. So what if in, say, the local police, description of a job that you put in that you can't participate in this type of speech, even outside of your job? Would that fly, or would the Supreme Court and First Amendment always win out?
Something like that, I think they would consider overbroad and vague. And I think it would be deemed to be unconstitutional. And yeah, overbroad and vague, because it's saying anything outside of this. And so you're going into the category of private speech, number one, which could be speech that you're making on a matter of public concern that a normal citizen would make. And you're also looking at it could be just a very broad content regulation of speech. Because there you're saying all the content of it. You can't even participate in any sort of way. Another example that I can give you of when employers were allowed to discipline employees for speech. I don't know if you all know about this, but I'm addicted to TikTok, which is actually a problem. But there were these nurses from Emory Hospital who made a video about their icks. They were labor and delivery nurses who made a video about their icks, and they were complaining about things that they didn't like about the patients in the hospital, and they were pretty egregious. Yes, that was speech, but this far, I don't know if anyone has challenged whether or not it was a constitutional violation. There's a question as to whether or not it was constitutional violation. Now, my mom's a nurse, and so they're told you can't say anything about patients outside of the hospital, because then you're getting into like HIPAA. You can't disclose patient information. There it constituted opinions, but you're in a hospital environment, so you don't know whether or not there are patient records being shown, anything that pops up in the video, and also the impact of the employees making such derogatory comments about patients. And then, of course, as a result of the speech, then the floodgates opened of people who had had babies at the school, at the hospital, and had really bad experiences with their babies dying or their babies being harmed in some way, their complaints not being taken seriously by the hospital. And so then that speech became almost like ripe as proving ground as to negligence for the hospital. So yeah, HIPAA would, wait a minute. Yeah, HIPAA would impact the incident. And that goes to whether or not the statements they made could reasonably be seen as identifying specific patients. Also, whether any patient information was visible in the videos. And so, of course, the video has been taken down. I haven't looked for it again, but they are in a hospital setting. So there could have been something posted. There could have been something on a desk that included patient information. It was a really dumb thing to do in so many capacities. That's the only way I can describe it, because I wouldn't want to go to that hospital and have a baby if I saw that video. So I don't know whether it will be challenged on First Amendment grounds, which would be pretty interesting, but that's a First Amendment issue. Now it's a private hospital. I think Emory's a private hospital. So then it's a question of whether or not they can take that action, but it always eventually comes down to a First Amendment issue.
What do you think about the employers that require, some prohibition that if you're going to participate in social media, you can't identify yourself in any way as who you are? So I can't put on my LinkedIn or on my Facebook or whatever that I work for the police department or I work for the school department.
So I'm just thinking this off the cuff. I'm thinking of a way in which that could become a problem. I could understand why an employer would want to prohibit you from putting your place of employment on social media, because in some ways it could protect you, because it could take out okay, are you making this speech in a way that would make it seem like you're representing the organization? But at the same time, say for instance, you have a situation in which someone is serving as a whistleblower and of something that is going on, then that job title becomes important as a matter of public concern, because you're saying this is what's happening. So sometimes it comes up with police officers who are disciplined for whistleblowing, because then it's actually legally relevant. Their position is actually legally relevant because it lends itself to what knowledge do they actually have. So I think it cuts both ways. And I do think it's fact specific, but it does seem particularly overbroad. However, at the same time, the employer does have a right to protect their name, and the employer has First Amendment rights to control what could be deemed to be their speech or representative of their particular views. So I'm not sure about that. I would have to think about that more closely, because I could see how it could protect both parties, but I could also see how it could inhibit the speech of the employee if the employee is using that as their source of authority, particularly in a whistleblower context.
Thank you.
Because if you're blowing the whistle, you're saying this is happening there, and then you also want to substantiate it by saying, and I know this why. And so that's why there's a question that I would have to think about more carefully.
Other questions, thoughts?
I go back to the K through 12
Mhm.
situation. You talked about the latitude that's given to regulate free speech by the school administrator or what have you. Given where we are in terms of this nature of handguns coming into the school
Mhm.
and the prevalence of that and the intent to prevent that from happening, have you found that either the courts or the schools have used what power they have in that kind of regulation of handguns to be the argument for examples of hate speech or what have you?
So are you saying in terms of making threats?
I would, well, that's one level. I was gonna go a little bit less than that, necessarily making threats, but disruptive. You talked
Yes.
about, yeah, disruptive, yeah.
It has. Gosh, what is the case? I think it's either. Okay, I don't want to. Was it Wisniewski? I can't remember the case. I don't want to cite the wrong case. But there have been cases in which I think it was an elementary school student who drew a gun.
Yes.
A gun is expressive speech. However, that can be regulated if surrounding circumstances indicate that it somehow is causing a threat. So for instance, if the student is consistently displaying certain behavior, then regulate it, because now we're getting to a threat. And even if it's just that particular instance, and it looks like it's threatening to anyone in the school environment, then it can be regulated. Because of the unfortunate prevalence of school violence with guns, that is a heavily regulated area. A lot of schools have zero tolerance policies for things like that when it comes to depictions of weapons or any sort of written threats.
And that would extend beyond the actual building of the school, but would include the bus bringing them to school or taking them home.
So yes, it could.
Mhm.
So for instance, a bus is considered where the school is standing in loco parentis, because the
Yes.
bus has care of the student. So it would extend to the bus. Now it's different when you get to internet speech, because then it becomes a question of whether or not the speech is likely to reach the school and whether or not it's likely to be perceived a certain way. And by reach the school, meaning, I know it sounds crazy, by reach the school, come to the attention of students, administrators. That's what's meant by reach the school. And also, even if it's something that's very limited, is it still something that is threatening to the school? Then it's normally regulated outright, because schools just aren't willing to take that chance.
Yeah. And I assume it probably gets even more dicey when we talk about something that happens with the PTO, the parent, and what they say. Whether
Yes.
Yep. That's rough.
Yeah, the PTO, because a lot happens at those meetings. A lot happens at the meetings. And when you're thinking also about expressive conduct, it can be something as a fundraiser. That can be expressive conduct.
Yes.
What message is that conveying?
Any other last comments, thoughts? I know somebody put something in here and about whether there's any, and I would raise that to you, Professor, sort of, you know, one pager or sort of definitional sheet, anything you know that would be helpful to people for that?
So one thing that I could do, I know this sounds very schoolish. I have a really good book that I use. And I would be more than willing to make copies of that section
That would be
because
wonderful.
it's a very explicit. It's one of my con law books. It is very, very explicit. And I think it provides great examples. And I can circulate those copies. I'll get my assistant to do it because I'm terrible at making copies. Everything turns out black. But yeah, I can do that for you.
That would be
And
great.
so it's more than one page. It would be more like 20 pages. But it has the cases. And then I can also, this is what I can also do. I can pull a few law review articles for you.
All right, even if you just, and don't, even if you can just send us those sites, we'll have people pull those and get them out to people.
Okay. Yeah, that would
That
be
would
good.
be
I
great.
have my students working on an off-campus speech right now, so those would be easy to find.
All right, that would be wonderful. That would be one. This is incredibly helpful. This is
Oh, thank
a
you.
complex area that we seem to be picking our way through on a, as Alice mentioned, almost on a weekly basis. We have so many of them coming in.
And I think what it is it's not intuitive.
Right.
Because you think, well, you just can't, you shouldn't be allowed to say certain things, but then you just also have to think about the purpose of our Constitution and the purpose of the First Amendment and how far that could swing, because you've had First Amendment cases attempting to prohibit civil rights organizations and
Right.
parades. So it goes both ways.
Thank you. Thank you so
You're
much for being here
welcome.
today. Thank you.
Thank you for having me. Everybody have a good day.
Thank you. Bye-bye.
Bye.
Thank you to everybody for being with us today. Thank you to Antonia for getting us together. We will see everybody again on February 9th. And in the meantime, remember, you know, this discussion was really prompted by people's questions. So if you read something, think about something that you'd like us to address, just shoot us an email about that and we will put that together. So be well, take care, be safe in the snow this weekend. Take care.
Thank you.
Bye-bye.
Thank
Bye,
you. Thank you, Mary and Nazda.